This case is In Re BW, appeal of Blair County Department of Human Services. Representing the Department of Human Services is Mr. Stephen D. Wicks. Representing the Pennsylvania State Police is Mr. John J. Herman. Representing BW is Mr. Philip Robertson.
Good afternoon. In this case, the appellant is seeking to exchange his records related to his involuntary commitment to a mental health facility. The issue is whether a threat to harm another person without an overt act in furtherance of that threat can justify the involuntary commitment of an individual under the Mental Health Procedures Act. With that, we'll begin with Mr. Wicks.
Yes, thank you, Your Honor. So the Superior Court in this case determined that BW had only issued a threat, had not engaged in an act in furtherance of the threat. And we submit to the court that when you examine what he actually said, it constitutes much more than just a threat. He specifically said he would strangle another person to death. He gave the person's name, and he stated that he would do it the next time he saw him. And so, in effect, he had a completed plan, and the only thing waiting for it to be executed was for their paths to cross. We submit that the rules of statutory construction and the case law support the conclusion that the words and the plan of BW satisfy the requirement for an act in furtherance of the threat. The language itself is not ambiguous in the statute. We submit that the plain language edict from the rules of statutory construction applies, and that the common and approved usage of these words, in effect, result in the conclusion that act in furtherance means simply to do something to advance someone's interest. And there's nothing from that language that would suggest that the do something must be in the form of a tangible act. The case law we submit supports that interpretation. If the court looks at the Smirkonish case from 2015, that was a case where there was a suicide threat followed by research on options and ways to commit suicide. The Smirkonish court equated the research in that case to the raised cane in the RD case that we've cited. So the Smirkonish court saw no difference between the tangible act in RD and the intangible act in Smirkonish. I'd note that the Smirkonish court did not cite the sister case of RF, which is the other case involving suicide threats plus research to effect the threat. But RF essentially mirrors Smirkonish, just albeit with a different justification. RF relied upon Mertz and the handwritten suicide notes. I would note, Your Honors, that there are distinctions between BW and Smirkonish and RF. I mean, both Smirkonish and RF had a physical act, which is almost ridiculous for me to mention it, because the physical act was to turn on a computer and do a search for information. But to make that a controlling distinction would be, I would submit, an absurd result in violation of the rules of statutory construction, because the focus of both Smirkonish and RF was the search for a plan, not the physical act. They are also distinguishable in a sense because both of those cases had an act that was temporally and physically separate from the threat. And unlike Smirkonish and RF in the case at hand, we don't know when BW completed his plan. But what we do know is that BW was much further ahead of the actors in RF and Smirkonish and in Mertz, because in those cases, they were only I would suggest, at the beginning edge of developing a plan, whereas BW was all the way there. The other case I've cited to the court is In Re HD, which regrettably is more of a blurb in a footnote, but the threat is similar in the sense that the threat and the plan, because in that case, the HD was hearing sounds in her head and planning to jump off a bridge, and all of that came out in one utterance. But there is a plan there. But unlike the case at hand, in HD, we don't know what the details of the plan were. We don't know if she knew when she was going to do it or had decided when or where. So those cases are distinguishable in the sense that, again, BW had a completed plan in place. The Mertz case, the Common Pleas Court case, which was relied upon by RF, is also easily distinguished in the sense that if it's true, I mean, if this court views Mertz as having an analysis that is reliable, if writing the threat down constitutes an act in furtherance, then we submit that a fully developed plan is, again, much more apt for purposes of having the act applied to the question of whether there's an act in furtherance. The other case I want to mention, which is relied upon by by BW in particular, and was relied upon by the Superior Court, which is the unreported KM case, which we submit again is distinguishable because in that case, the actor said that's fine in referencing a high medical bill. When it's too much, I will end my life. I mean, that's a conditional threat, not a present tense, I'm going to do it threat. They would have to wait for the bill to become too much. He also said he could take a .350 mag and put it to his head and pull the trigger and kill people with no care. He didn't say he intended to do that. He said he could do that. And there was nothing to suggest that we know of that he actually had a .350 in his possession or accessible to him to carry out the threat. So based upon the law that has been decided to date, Your Honors, we believe that BW with a developed plan is on much more solid ground than cases where the research has just begun, or the cases I've cited where the details of the plan have yet to be inserted by the actor. Does the court have any questions?
No, we have.
Counselor, it's Justice Donahue. Isn't it your point that it was up to the physicians in this case to determine whether or not the plan was sufficiently developed to constitute a threat so as to cause harm to another? Why aren't you talking about the physicians? I mean,
well,
is that controlling here?
Well, the physician made the determination, and the question that was decided at the Superior Court was that there was no act in furtherance. So we agree with the physician and that the physician made that determination, but the Superior Court isolated the issue to the question of whether it was only a threat and there was no act in furtherance. That's what brought us to this court.
Thank you.
Hey, Counsel, Justice Blair, I just have a question. I like to understand cases. I understand that Dr. Rule was a PCP And Dr. Boggs was a psychologist or psychiatrist with a MD degree. How does Dr. Summerall fit in? Where does he or she get into this case?
As I understood it, he was a physician in that office, and that the information was originally secured by Dr. Rule, and Dr. Summerall, came on the scene and did the evaluation and made a referral.
So they're both in the general PCP genre.
That's as I understand it. Yes, Your Honor.
Thank you. Thanks, Chief.
Thanks, Mr. Wicks. We'll hear from Mr. Herman on behalf of the Pennsylvania State Police.
Thank you, Your Honors. John Herman, Governor's Office of General Counsel. It's always my honor to be before this court. Thank you. Your Honors, I think one of the critical things that should be highlighted is why the state police are involved in this case, because I think that's a critical point in considering the case. The expungement analysis here is occurring under the Pennsylvania Uniform Firearms Act, 18 PACS, section 6111.1G2. This court in the In re Wenzel case in, I believe, around 2017 took a very in-depth look and review of the application of that. And this court held that a review under that section requires deference to the physician. And I think that's an important point to make. But and I would note, of course, we agree with Blair County's position. But I also think it's important to highlight there was two critical points in Judge Lazarus's dissent. And frankly, we believe that she applied the right framework in this case, both to looking at it as an act in furtherance, as well as looking at the statutory construction of 50 PS 7301B1. The last sentence of that statute provides that a clear and present danger of harm to others may be demonstrated by proof that the person has made threats and committed acts in furtherance. I'm paraphrasing slightly. I think the key word there is may be demonstrated. It's not must or shall, it's may. And as far back as 1986, a panel of the Superior Court noted that. They basically stated that statutory language there doesn't require that threats and act formula to be used, and that other means therefore must be permissible. They particularly highlighted the contrast with section 7301B2, I believe 3 Roman I, where the word shall is used. And Judge Lazarus picked up on that, and she noted that. She said that she believed the majority erred by holding that you had to have an act in furtherance of a threat to commit harm to be a necessary condition to find an underlying involuntary commitment to be valid, to be supported by sufficient evidence. And I think that's a critical point, that even if one looks at this, even if one questions whether there is enough, an act in furtherance, quote unquote, is here, the point is so much that the act itself, the policy of the act, is obviously to protect an individual's liberty, but it's also to protect the public and to protect the health and safety both of the individual and potentially others. And the case that Mr. Wicks cited to In re HD it was decided alongside In re SLW. And in those cases, which were decided together, they talk about the need to balance those two things. And I think that's what we have here, Your Honors. The statute clearly permits a doctor to look at an individual, and if they are a clear and present danger, to make sure that they are given the treatment they need and that others are not harmed. And I believe, like I said, that's what we have here, and that's exactly, particularly in light of the fact there were multiple physicians involved in this commitment.
Mr. Herman, Justice Blair, with greatest respect, I disagree with you and Judge Lazarus, and that might mean when we're done writing, I'm in the dissenting posture, but still, let me ask you about that.
Yes.
It seems to me that the way 301B1 is constructed is in the first sentence. It says clear and present danger to others shall be shown. And then it explains what you have to show, which is, as you know, inflicted or attempted to inflict serious bodily harm on another and a reasonable probability that will occur again. Obviously not here. So then you go to the last sentence, and if I was drafting this, I wouldn't have drafted it quite this way. But when it says a clear and present danger others may be demonstrated, it seems to me that the word may there says this is an alternative to the first sentence. You can do it by showing, as I indicated, the first sentence, attempt to inflict, and it may happen again, or alternatively, which is again why it says clear and present danger may. You can show it by showing that threats of harm have been made. And then the important word to me is the word "and" in that sentence. Do you see that? And has committed acts in furtherance. So it seems to me that the word "may," that's my whole premise, but to make the question much more succinct, seems the word "may" is to signal this is an alternative to the first sentence. And the word "and" says you have to show both threats of harm and acts committed. That does not mean you don't prevail in this case on the basis of the argument from your co-counsel, but it does mean that I don't agree with your statutory construction, and I wanted to give you a chance to dissuade me.
I take your point, Your Honor. But if you look at the structure of the act, as you clearly pointed out, you have to have that clear and present danger is laid out in the first sentence. But I believe that's where it's important, to the extent it is ambiguous, to the extent it's maybe not entirely clear what was meant there, I believe it's important to look at the word "may," that the legislature did not necessarily intend to restrict physicians to a strict formulaic reading. They were presenting that there may be alternative means. And I think that's where it's important to consider the policy. I agree. If you're applying that test, you have to read it. You have to include the word "and," as you noted. But I think really when you consider the policy of the act to give individuals help when they need it, essentially, when you look at it that way, I believe it's fair to look at this and say the legislature was essentially leaving the door open when the doctor sees a clear and present danger. I mean, you have to anchor it in the dangerousness in the clear and present danger standard. But I think what they were doing, what their intent was to allow a physician who's presented with a situation like this, Your Honor, an individual comes in, makes a threat, and I believe the words Judge Lazarus used were a target and a method. And that's consistent with other cases. There was an identified target and method here, and that regardless of how you look at this, whether it's considered an act in furtherance or not, I think the point is the statute is drafted in such a way that a physician is able to act, because otherwise, as Mr. Wicks pointed out, I think you end up with an absurd result. I hope that addressed your question, Mr.
I think it does, and I would just suggest to you that I think your better argument might be to argue for a expansive definition of act in furtherance, which could maybe consider methodology to effectuate legislative intent, which is we don't want, for instance, in this case, the co-worker killed before we get this gentleman some help.
I would agree with that, Your Honor, in the sense that I think we believe this is an act in furtherance. We just felt it was important to highlight that we believe there's two valid avenues for this court to consider that Judge Lazarus had two solid points.
Fair enough. Thank you.
Mr. Herman, it's Justice Todd.
Yes.
I diverge from my esteemed colleague, Justice Blair, a little bit in the statutory analysis, because I tend to agree with you in your premise argument. But if that is not accepted by the court, it does seem clear to me that if an act in furtherance is a strict requirement, that the development and articulation of a plan does qualify as an act in furtherance. And I wondered if you wanted to comment any further on that.
I believe that's correct, Your Honor. I think Judge Lazarus, in terms of considering this as an act in furtherance, and I appreciate the ability to comment on that. I believe, again, referring back to Judge Lazarus's, I believe, very cogent dissent in this case, when you look at the case law, there's a common theme of a target and a method. We had that here. We had an identified target, and we had a method in which it would be carried out, which is manual strangulation. I'm inserting the word manual, but strangulation with someone's hands. And that's consistent with a number of cases, the Woodside case, for example. Now, in that case, the individual did acquire a rifle scope. But the point is, he had made a comment, and there was some other conduct admittedly. But I think the core of that analysis, and Judge Lazarus touches on that, is that there was a comment about harm to another individual and doing it with a rifle and scope. And Judge Lazarus does a really nice job of laying that out. When you have a target and a method, you have a danger to someone else, it's permissible to find the act in furtherance. It makes logical sense on the policy of the act.
Thank you, Mr. Herman.
Thank you, Your Honor.
Okay, thank you. Thank you both. We'll turn to the appellee, Mr. Robertson.
Thank you. May it please the court, Phil Robertson here for BW, who is present here. Our main position is that we disagree with only whether or not the statements made by BW is actually a plan. Obviously, if there's a specified detailed plan, we believe that that could be enacted in furtherance, but the comments made by Mr. Walker is not an act or not a specified detailed plan. If you read and I know you have, if you read the transcripts, the only comment he made on his own was he was so frustrated, and based on the employment harassment as outlined by the decisions by both the lower court and the superior court, he was frustrated, go to the doctor trying to get some help, and he says, I could just strangle my coworker. Only after being barraged with questions from the doctors and other mental health workers about what are you going to do, when are you going to do it, he then says, well, I'm going to do it next time I see him. So it wasn't a plan. Our position, it's not a plan. And I don't believe...
Could I jump in just with a quick question, sir? Just
Yeah.
a framing question. Suppose we agreed with you on a cold reading of it. Suppose we read those comments by your client just as you would read them. Is that in a way beside the point, or looking at it with the wrong lens? I guess what I'm asking you, pursuant to our decision in Wenzel, isn't there a heavy deference given to the physician who actually experienced that interaction with your client and would have received those comments face to face, as it were?
There is, but there is also the judicial process for the judicial review, which is what we accomplished. So the doctor does have discretion and deference in his decisions as to what he sees, but like in everything else, it's up for review, and the review is based on the statute as to whether or not there was actually, one, a threat of harm, and two, in this case, our position is there has to be an act in furtherance. And like Justice Blair was saying, I believe that's proven, or I believe that's the case, because in every case that's cited, there's always an act in furtherance, and the Superior Court or the Supreme Court has always went and gone through and determined what the act in furtherance is. And here we have, as the Superior Court in the majority opinion in BW says, here we have basically mere words. And our position is the mere words as to when it may take place is just an extension of the threat. We don't have the act. As in Smesher Korsh in 2015, we had him internet researching. We don't have that here. We don't have him holding a cane. Yes.
Justice Blair.
Yes, sir.
First of all, let's make sure that we agree on the facts. Is there any dispute in this case that he said, even, and you want to say it's not credible, but I just want to make sure that we have the facts that he said that I'm going to kill my coworker when the next time I see him. How? By strangulation, I think it was.
He did say that, but not all at one time, Your Honor.
All right, he did say those three things to the doctors.
Yes. The last two was after being questioned numerous times about the doctors. His initial comment was, I could just kill or strangle my coworker because of the stress I'm under.
This is perhaps an unfortunate case, but as Justice Weck said to you, under Wenzel, which I may have written, I'd have to go look at that.
No, I wrote it. Justice Blair, I wrote Wenzel.
Did you write Wenzel? Fine job. I'd like
to ask him about what happened at that hearing based upon that.
Well, go right ahead. I'll come back if I need him.
Yeah, I was a little bit confused as to how it came to pass that your client was testifying at all. Since under In re Wenzel, the trial court had to base its decision on the sufficiency of the evidence based on the notes that were available from the physicians who conducted the review. And so all of this extraneous information that you're talking about, I'll give you the opportunity. I mean, as I understand the notes, they're like notes you would generally see in these contexts. They're very brief, they're very succinct, and very to the point. And so this discussion of what your client meant and how it only happened after questioning, et cetera, that's not on the record before the trial court. Oh,
Well, Judge, I mean,
your client testified and should not have testified.
well, I believe there was a motion for that, and we argued that, and I believe our position was, Judge, that just reading the records does not give the context or the feel as to what actually happened that day, and the court was allowed us to have testimony concerning that.
I'm sorry to interrupt you, but that was precisely the argument in Bensel.
I understand.
And we decided very clearly that given the context of the review that's taking place and the statutes that were at play, what the trial court had to look at was whether or not the evidence was sufficient based upon what appeared in the records from the physicians or others who may be involved in the commitment process. There's no question that your client had, or at least for my understanding is, two of the physicians found it pertinent, if not critical, to note that the method of killing was strangulation and that there was an identified and named potential victim. Is that correct?
That is correct, Your Honor.
Okay, so at least two, using the nomenclature that counsel for the state police used, there was a target and a method that was identified by these physicians in their findings.
That's correct.
Okay.
But our position is even just taking what's in the record, Your Honor, it's still not enough to satisfy the act in furtherance because, as the Superior Court in this case said, mere words is not enough. You have to have some type of act, as looking up something or actually, you know, he did make no threats to him personally. He didn't call him. He didn't have any communications, as the courts found, with the alleged, you know, who the victim or alleged victim. So it's just comments, and I think that's what the Superior Court's saying. Comments in and of itself, even though they are a threat, are not sufficient to be included in acts in furtherance.
Mr. Robertson, it's Justice Todd. Is it your position then, as a rule of law, that we would write for the entire Commonwealth that, as inferred by the Superior Court majority, words alone without some physical manifestation can never constitute an act in furtherance?
I don't know if it could never, but I believe it depends on the, like I said at the beginning, the detailed specified plan that is here. Our position in this case, there is no detailed specified plan. The fact that he says under questioning that he's going to harm somebody the next time he sees them, our position is that's not a specified detailed plan. And I think that's what the Superior Court found too. But if there's somebody comes in with a specified detailed plan, then yeah, I think that's enough. But in this case, that's just not enough. And I think that's what the Superior Court has found too.
And what else would he, Justice Blair, I want to follow that. What else, in your estimation, would he have had to do to take this plan from an act in furtherance to take it from a incohate to cohate act in furtherance? Well,
like if he would have said that he was going to do it at a specific date, he was going to wait for him behind his vehicle or wait for him when he comes across a certain place at work, that's when he was going to jump him, or at home, he was going to follow him. If he had a specific detailed plan that way, then that's different than just blurting out the answers. Hey, I'm going to do it whenever I see him next, because we don't know when he's going to see him next. So he may not see him. And as Attorney Wicks indicated in that one case, that could be a conditional threat. So even though there's a specified name, and I would point out, as Mr. Wicks did and the Superior Court did, KM is basically the same thing, where we just have words. I mean, he's threatening that he could take a gun to people, and just because they're words, that wasn't sufficient to meet the act in furtherance clause.
Thank you.
Any other questions? Okay, if not, we will conclude by saying that we appreciate the argument of all three. Council will take the case under advisement and conclude the argument session for today. Thank you.
Thank you.